Hello everyone, I'm Rahul. I'm studying Master in Professional Accounting in Holmes Institute, Sydney, Australia. Today I'm making this video as a presentation for our assessment of business and corporate law. It is a assessment video and which are made or prepared by a group with 5 members, and the name of my team members are Nisa Prajapati, Nisa Gautam, Bobby Wasti, Ayush Nupane, and Rahul Portal. Today, I'm going to talk about a case which is between ASIC, that stands for Australian Securities and Investment Committee, suing Padbury Mining Limited, held in 19 August 2016. Padbury Mining Limited were endorsed by Essex with the declaration of Okaji project regarding the deep water port and railway networking in Okaji, Western Australia. To complete the project, the company was entrusted with 6.5 billion American dollar. Later, after 2 years, which was in 19 August 2016, the federal court had passed the ruling to two authorities, head of Padbury Mining Limited, Gary Stokes and Terence Quinn, with the consent of misleading and deception. As a matter of fact, there are three defendants. One is company itself, Padbury Mining Limited, and the second is Managing Director Gary Winstock, and third is Chairman Terence Quinn. The first defendant company, who secured funding of 6 billion in order to construct deep water port and railway network at Okaji, which was misleading and deception. That the availability of fund was not able to satisfy the condition under which Okaji funding was released. They also breached the Corporation Act by not notifying ASX Australian Stock Exchange on 11th April 2014 about the release of Okaji funding announcement. As per the director of Padbury Company, Managing Director Gary and Chairman Terence breached or failed to discharge their duties with degree of care and diligence that the reasonable personnel should exercise. They authorized and approved the release of Okaji funding instead of permitting the company to make a secured funding. Likewise, before making the AXS Okaji funding, the ASX at Padbury request placed a halt on the trading of Padbury shares. At that time, the shares were trading at the price of 2 cents per share, and after 4 hours, the share hit a height of 5.2% with more than 200 million share trades. As for the reason, the Gary Stroke and Terence Quinn were disallowed to supervise the organization for 3 years in length and were fined 25,000 per each to violate their disclosure obligation as officials. They were moreover asked for dispensing ASIC cost of $200,000. The continuous disclosure obligation of the ASX unrecorded association is troublesome and must be treated by means of good care and refrain of from the risking an infringement, and an incapability to take action is regard of the trial, as the Padbury case shows up, and the manner could incite financial specialist class exercises as infringement by various other recorded units have shown up.